I'm not trying to be fatalistic. I'm trying to be realistic. And if the odds are 99% chance you're going to be before a judge for sentencing, why wouldn't you start right now, getting
And I
ready
tell
for
lawyers
that?
to take a page out of the death penalty lawyers book, which is they do the penalty phase first and then the trial.
From the very moment a defendant is involved in this system, someone else has control over their story. They want to define that person solely by the crime they may have committed. You have a sentencing date set, and the stakes are high. Both lawyer and client need to do everything in their power to prepare. But the question is, are you ready? I'm Doug Passon. I'm a 25-year defense lawyer, a sentencing consultant, and an award-winning documentary filmmaker. In Set for Sentencing, I'm going across disciplines and outside the box to help both lawyer and client expand their perspective, build on their skills, and get real results in the form of significantly reduced sentences. All of this in service to one goal: to bring more fairness, more compassion, and more justice to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, this is Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona, helping us get set for sentencing today. A very special guest, a friend, a mentor, and colleague of mine, attorney Alan Ellis. Welcome, welcome, welcome. How are you today,
Thank you, Doug.
Alan? It's good to see you. It's good to see you on the podcast. So let me tell everybody just real quickly about you. Alan is the chief captain of the ship that is the law offices of Alan Ellis. It is a national practice that focuses on sentencing. It focuses on post-conviction relief, and it focuses on Bureau of Prisons, prison issues. So, so what did I miss? Federal sentencing, prison, post-conviction relief. And those are the three big ones. There's a lot of other aspects, but like I said, he is a colleague of mine. I work with Alan all over the country on all kinds of cases, doing mitigation type work and sentencing video work. And Alan's really famous for assembling great people. He uses what's called a team approach. Tell me what the team approach is real quick. So
Team defense, basically.
team defense.
It's working with more than one person on the case.
Yeah. And you've got basically people for every aspect of it, whether it's BOP, whether it's sentencing statistics, all of it. So we're going to talk a little bit about that today, but mostly what I want to talk about today is, so Alan's a prolific writer and he's written countless articles. I think the most popular thing that he has written is this thing, which is the Federal Prison Guidebook. And this is now in its 6th edition. It just came out. And Alan Ellis and Maureen Baird are now listed as the chief authors. Now, there's a very fine print with some contributing editors, and yours truly is right at the bottom. But this book is really immensely popular. It's on every bookshelf in every federal defender office I've ever been in. I think every federal judge has this book within arm's reach on the bench. And inmates know this book far and wide, and it's been a huge resource. I notice it just keeps getting fatter and fatter every year.
It's like 900 pages a time.
Yeah. And I thought about that, and I think that that is the one thing the book and I have in common. I keep getting fatter and fatter every year, too. I have to go to a wedding this weekend, and I tried on a tuxedo that I haven't worn in 10 years. That ain't happening. But that's a whole other story. So anyway, the articles, the writings that we're going to talk about today are so key because they're so central to what we do in the sentencing arena. So Alan has written a series of articles called A View from the Bench, published in Law 360. And what he did is he talked to many federal judges, primarily district court judges, the ones who are on the front lines of sentencing. And he wanted to know what moves the needle in court, what makes a difference in the way that we advocate for our clients. What do you base your sentencing decisions on. And what I think is most interesting about this is you basically got almost what 40 judges to participate in this project.
Yes.
How do you first of all, like how do you get 40 judges? Like,
Well,
just because they know you, right?
yeah. I've when I contact them, I ask them to, I can interview them. No problem.
All right. Well, that's the benefit of writing the book, I guess, because I haven't gotten a judge to agree to come on the podcast yet, but this is the next best thing because you talked to all these judges and you distilled this down into really, really great sentencing advice. So that is what we're going to talk about here. And we can't talk about all of it, but we're going to hit on some of the high points. So let's just start. Let's just dig in and speak to the idea of the judge in general, because there are hundreds and hundreds of judges and they're human beings, which means they're all different. So what is the first piece of advice that we need to understand when we're gearing up for sentencing as it pertains to the judge?
Well, the first judge I interviewed was Judge Jed Rakoff from the Southern District of New York, a very well-respected judge. And he said to me, Alan, first thing out of his mouth was, Alan, know your judge, which means know what they like, what they don't like, and how do you find it? Talk to the federal defender in that district.
Yeah, the federal defenders in front of the same judges day after day after day. They've seen sentencing, way more sentencing decisions than that. Are there other, I know there are some other ways that you can kind of do the homework and find out about them. What else do you use? What else do you do?
As far as know your judge?
Yeah. Specifically, you've got a book or like there's some kind of resource that lists all the, I forget what the name of that book is.
Almanac of the Federal Judiciary. It has bios and lawyer evaluations of the judges.
Okay.
So
Good.
whenever we get a new case, I always turn to that book and see who we're in front of.
Yeah. Okay, good. So know your judge. There's just certain things that, you know, some judges are influenced by more than others. I'll give you a simple example. Kids. You know, we have to be very, very careful when we incorporate our clients' children into our sentencing mitigation story, because instinctively, I think judges think that we're using kids to try to manipulate or tug on heartstrings or do something that's untoward. And that's not the right way to approach sentencing. But there are actually some judges who are quite comfortable with even having kids in the courtroom, which is something I don't often do. So it's a good example of something they.
Well, I had an experience years ago where we had the mother and the child in the courtroom, and the father was being sentenced, and the kid started crying, and the judge said, "Get that crying kid out of here." So I learned my lesson that time.
Yeah, I've had that happen a lot too. Absolutely. And by the way, it's like, you know, sentencing occurs usually, always on a weekday during school hours. So the question is, if there's a kid in the courtroom, why is he not at school? And why do you need this kid to see their father brought in to the courtroom in shackles in an orange jumpsuit? How is that helping this child that you're supposedly so concerned about? And of course, the most common thing when you say, please, Your Honor, don't sentence my client to prison because he has children that rely on him, we know what the standard response to that is, which is, should have thought of that.
Yeah.
when you did what you did. So, but anyway, we're getting off track. Let's go back. So I want to talk now. So know your judge. Great advice. Let us talk about mental health aspects of this. Many clients have them. So what do we need to know when it comes to mental health?
Studies show, Doug, that 1 in 4 inmates in prison are suffering from a diagnosable mental health disorder. So because crime is a deviant behavior, I oftentimes like to have my client seen by a mental health professional. And I found, talking to judges, that they don't want a hired gun forensic expert. They want to see your client's therapist in court.
Okay, so that's a huge thing. Let's drill in. So ideally, your client is already in therapy and has been getting treatment for some extended period of time.
Ideally, before he's been caught. better. Yeah.
And so if you don't have that, I think it's probably good advice to, people. Well, let's just basically, when do we start developing mitigation in a case?
I like to say as soon as the check clears.
Okay. So immediately.
Yes.
And I think that concept is often lost. Lawyers maybe want to get through a plea agreement, get towards the end stage before they really start drilling in. But what if you, started at the very beginning and realize your client has a mental health condition and hooked him up with a therapist so that if he didn't do it before he got in trouble, at least he's been doing it for the months or the year leading up to sentencing.
Well, in those cases, Doug, rather than give the judge the whole written report from the therapist, I like to give him a few passages because I like to have the therapist in court because I want the judge to engage in a conversation with the therapist. And that's very effective.
Yep. And we've also presented their stuff on video as well in some
Yes.
cases. But so in terms of long-term therapists versus hired gun, the benefit, I think, is what I hear you say, is that these are people who really would know the client because they've been working with them extensively versus some hired gun who just sat with them for 3 hours and wrote a report and sent it in. Okay. So, and I found that the other benefit to having someone who really has worked with them and knows them well is that's one more person who can really tell their story on a deeper, meaningful level. Because sometimes our clients not able to say everything they need to say themselves, but the more they know, the deeper they can get involved in conveying it to the judge. Okay, so
years ago, I was doing a presentation to a group of lawyers, and also on the panel was Judge Nancy Gertner, who's being seen now on, he's a commentator on the Trump document situation for CNN. And I turned to her and I said, Judge, what do you do if you got a client with a record as long as your arm? He's an inner city youth. What do you do? Tell me your story, Al. Tell me a story.
Yeah. And that's another fact that I think is lost a lot of times. We lawyers are not trained to be storytellers. We're trained to deliver information and swim in law and guidelines and this sort of thing. When at the end of the day, in my experience, is not what moves the needle. Telling a true story about how a client got in the trouble they got in and what they've done to make up for it, and then why they're not going to be back again is powerful.
Most lawyers or defense lawyers do it because they like to cross-examine the prosecution witness and give the closing argument to the jury and hear the word not guilty ring out. Well, in point of fact, in federal court, 92% of people plead guilty. They don't go to trial. And of the 7% who do go to trial, the government wins in 80% of the cases. So I say if you're charged in federal court, you got a 99% chance of being sentenced by a judge and an 80% chance of going to prison.
Yeah. Which is all the more reason you start at the very beginning. You say to the client, I'm not trying to be fatalistic. I'm trying to be realistic. And if the odds are 99% chance you're going to be before a judge for sentencing, why wouldn't you start right now? And
I tell lawyers to take a page out of the death penalty lawyers book, which is they do the penalty phase first and then the trial.
Absolutely. Absolutely. I had another podcast with death penalty, and they're helping us in so many ways because not only do they know about early mitigation, but they're so farther down the road and as to the kinds of mitigation to develop, and so much of it is applicable in any case. Not this, so there's a whole lot we can learn from death penalty lawyers. Last point on mental health. So let's say you haven't had a therapist that's been involved for a long time, and you don't necessarily want to just find a hired gun. What is the best course of action to choose someone to evaluate your client that'll be best suited to persuade?
What I like to do is I ask the prosecutor who he likes to use. And I did it one time after a stunned silence. He said, I'll get back to you tomorrow. He did, gave me the name of the guy. I hired him. And guess what? He was great.
Yeah.
Because even though he's a prosecutor-oriented expert, he liked the fact that working for a defense lawyer helped burnish his resume and they're bulletproof. If he's working for the prosecutor half the time, the prosecutor is going to go to cross-examine him.
Yeah. And if we don't like the report, we don't have to use it, right? So it's a low risk. It's a low risk proposition there. Okay. Good. All right. So one of the sort of go-to moves that lawyers have been using for a long time at sentencing are sentencing letters. I think they're a mixed bag, but what's your take on sentencing letters?
I'm not a fan of them because I like the mitigation videos like you do, because the picture's worth 1,000 words and the video's worth 1,000 pictures. So
yeah,
rather
so
a canned letter, I like to have the person on video.
And I've seen lawyers in cases that really want to do right by their client, and they think getting as many sentencing letters as possible is the way to go. Do you think that is, and I admire the instinct and I admire the work, but do you think that's always the right move?
No, if I'm going to use sentencing letters, what I'll do is I'll pick the best ones. I'll quote from them in the sentencing memoranda that we do and attach the good ones as Exhibit A and the other ones as B.
I don't know if I told you this or not, but in my district, there's a local rule that says 10 letters. That's it. That's all you get. And my first instinct was, well, that's not cool because, what if there's 20 people? But the truth is, a lot of these letters are just say the same thing, and they don't say a whole lot of much of anything. And judges don't need 20, 30, 40, 50, 100 sentencing letters to get the message. And so what I sort of do to get around that is, if I have 10 amazing letters, great, those are the ones they get. But then in the sentencing memo, I can say, by the way, Judge, 50 people submitted letters for this. That's how much support he has. And here are the broad strokes, and I'll do bullet points. Great dad, hard worker, very remorseful, whatever. And then I'll drop a footnote to say, by the way, I did disclose all 50 of those letters to the government, just so the government can contest that if they want to. Then you've saved the judge, you've complied with the rule, and you've saved the judge the hassle of reading all these letters and condensed it into a half a page on your sentencing memo. So even if you don't have a local rule limiting you, it's still not a bad way to go. But here,
submit short stuff, not a lot of stuff, because it won't get read.
Yeah.
For the fact, I found that rather than argue a point in my memorandum, I like to basically, if I got a case that's on point, highlight it, hand it up to the judge.
Mm-hmm. Yeah.
Anything to do to make the judge work classes, appreciate it.
Yeah. Yeah. I think if you walked into any judge's chambers, the first thing you'd see is a stack of paper, 6 feet high on there. So the less they have to, now they have clerks to help them with that, but still it's a lot. And last point on sentencing letters is, people who are writing these letters have by and large zero experience with the system. They have no clue what matters. They're going to default to, he's a good person, I hope he doesn't go to jail, and it's going to not be useful. So what is our job as lawyers to guide that process to make sure we're getting the very best letters?
We use a sentencing instructional letter telling the writer what points to highlight and what not to do. I don't argue that the client is innocent. He's quite guilty.
Yeah. Don't criticize the system in general.
Yeah.
Yeah. And
it's so important. Judges have told me that it's so important at sentencing that the lawyer and the judge are on the same page, because only then will a judge find you credible.
I think it's important to highlight that it's one thing to give guidance about subject matter that's relevant and subject matter that is not relevant, but it's another thing to tell them what they should be saying, to spoon feed them the words. The words must always come authentically from a witness themselves. Otherwise, it's usually pretty obvious that they've been coached, and that's never helpful.
Yeah.
Okay. Restitution. What do judges
Ah.
say about restitution?
They say own the mistake and show sincere remorse. And one way of showing remorse is by paying restitution. In fact, one judge told me, rather than getting 100 character letters, I'd rather have each writer chip in $25. That's putting your money where your mouth is.
And a lot of our clients, so yeah, we handle a fair amount of white collar, so it is money involved in a case. But what are some of the issues that raise the judge's hackles when it comes to
The worst thing is that basically show the judge, well, if the judge finds out that you've been spending a lot of money on luxuries.
so
you've
gotten this,
restitution, that's bad. And
Yeah.
one judge said, I'm going to make sure he never gets out to spend that money.
and this is a good back to what the big point of starting right at the beginning of when you get a case. I want a client, one of the first things we're going to ask our client is, how much can you pay back right now? Or
Yes.
ideally, how much have you paid back before you even got in trouble? But if not, it's time to start. And we get a whole lot of, well, I got a mortgage payment, I got my lease on my car, I got my kid in private school, I got this and that.
Yeah.
What do you do with that?
You put the kid in public school.
You make some sacrifices and
Right.
show the judge, right?
That's it. If you got a cell phone, you can afford to pay restitution.
Got a cable bill, you got Netflix, you got every streaming, and all that, by the way, is coming out in the pre-sentence report with assets and liabilities. So the judge is going to know how our clients are spending their money. It behooves them to spend it wisely if they can, right? And I'm thinking of the one case we had with it was a resentencing where the judge gave him probation specifically because he was making these extraordinary efforts to pay back the restitution, right? So it's important. It's important if a person is making genuine efforts, and they don't have to pay back all of it. They just have to show that they're doing the best they can, right?
Yes. Even if you're going to pay $25, pay it. Just show the judge. And as far as I call it, own the mistake and show sincere remorse. Every judge I've talked to told me how important allocution is. Allocution is where the client talks to the judge in court, makes a statement to the judge. And that's huge. Like I was going over one of the articles, two of the articles that I wrote, which summarized all these interviews. And throughout all the article was allocution. And the lawyer had needs to prep his client for that, to tell the judge why he did what he did, why he's learned his lesson, why he's not going to do it again, and how he's trying to make the victims whole. And
yeah, that preparation is key. I think because one of the things we lawyers love and crave more than anything is control, and many lawyers are probably rightly scared that once they let the client go in court, they're giving up control, and you just never know how that's gonna go. But if you've done a really good job of preparing them, there's some degree of control there.
And if the client gets off the rails, the judge told me, hey, call for recess, a timeout, take the client out and talk to him, then come back.
Now, some of our clients, no matter how hard we try to prep them, they just, for whatever reason, they're not going to be able to do what we need them to do, speaking extemporaneously in court during allocution. What do we do in a situation like that?
Nothing. Judges told me they don't care if your client is inarticulate.
Okay.
They just want to engage you in conversation.
Yeah. Okay. And I think that's right. As long as judges understand what it is that's holding them back from communicating. And I may just say, he's super nervous, or he has a learning impediment, or whatever it is. I want to make sure the judge understands what's happening in that moment, so they don't misunderstand to say, they don't really care, or they're just not, they're phoning it in, or whatever else. And so even though they're going to speak in court, do you still say write a letter?
I mean, the client,
Yeah.
again, I like to put on video. I really do, because first of all, we control the video, but it comes across a real person talking to the judge.
Yeah. One of the things I love about the video, maybe most, is that it's an opportunity for people to speak in a far less stressful environment. You know, we're going to come into their home and they're, you know, nobody's hanging on every word, and they can think about it and be in a safe space. And ultimately you get something far more genuine in with all the witnesses too, you know, when they're in their element. You get better material. So obviously I'm a huge fan of the video. Okay, so let's see here. What about the this idea of, I've been actually attributing this quote to you, but after I reread the Law 360 articles, I think this came from a judge, but the idea of things a client does when nobody's keeping score. Tell me about that.
Well, it came from a judge named Judge Erickson, who is now in the 8th Circuit Court of Appeals. Before that, he was in the District Court in North Dakota. And I asked him, if you've got a horrible case, a heinous crime, what do you do? He said, tell me something your client was doing, Alan, when no one's keeping score. This before? He knows, tell what did he do? Good. Did he go over to our neighbors and say, Miss Jones, it's snowing outside, can I show you off for it? I call it the milk of human kindness.
Yeah, and these are the things that, listen, the government wants to define our clients by the worst thing they ever did and say that's who they are, and those things are the things that show their true character.
And these things get done, again, before he's in trouble, before he knows he's in trouble.
And so I do my 3 R's thing with the different sentencing, and I talk about redemption stories as one of the 3 R's of stories, and I say we can have past redemption, present redemption, and future redemption stories. And the past redemption stories, I think, are exactly what you're talking about. These things that are in their history that they've done way before they were ever in trouble, that really show who they are at their core and in their heart. And present are the things, you know, what have I done now to make up for this thing that I've done, to show that genuine remorse. And then the future redemption stories are, okay, I haven't been able to, for whatever reason, make this wrong right, but here's my plan, and here's the hope for my future redemption. And I've given it a lot of thought, or put a lot of effort into making sure these resources are out there for when I'm released from prison or whatever. But the last point I think about these things that people are done when no one's keeping score, again, goes back to early mitigation, because I don't really want my client to talk about themselves like that. I've shoveled walks, I've given money to charity, I've done this, I've done that, because I don't think that really comes off as a humble, like the way we want it to. The important thing is you got to find those people, because those are the ones who need to tell those stories about your client and show up for them when it matters. So that's a lot of work to track these folks down.
You mentioned current redemption. So one judge told me the best allocute never heard was from somebody. It was a case where the defendant had sold drugs to somebody who died from the overdose, and the defendant turned around in the courtroom to the parents and said, "Nothing, no punishment I get today is going to make up for what I did to your son." And that's very, very important. Again, you're apologizing to the victim. Not so many lawyers come in, they have the client apologize to the judge, the prosecutor, the auto mechanic. No, apologize to the victim.
Yeah. And that statement from that particular client, look, all of our clients are gonna say, I'm sorry if we've done our job bare minimum, but they all say, I'm sorry. So if they can say it in a way that shows they truly understand the depth of the harm that they've caused, that's going to set them apart from your standard acceptance of responsibility that we're shooting for, right?
You mentioned restitution earlier. So I think the best thing a lawyer can say in court is, Your Honor, I hereby tender to the clerk a check in full payment of all restitution.
Yes. And the problem, well, when I was a federal defender, my clients are all indigent, so they don't have the money for it. But, you know, that's
Even
that is
$25.
anything. That's right. Anything. Because a judge, if knows you're indigent and you gave $25, that's a lot. That means something.
Yeah.
That means something. Okay, so let's talk. We talked about early the importance of we've talked a lot about the importance of developing early mitigation, but let's circle that square, because what we haven't talked about is when do you start presenting this information to various decision makers in the case, because the judge is at the end of this process. Are there other decision makers along the line that we should be focusing on delivering this mitigation to in advance, well in advance of sentencing?
Yeah, the prosecutor. The
Why?
probation officer who's drafting a pre-sentence report.
All right, well, let's start with the prosecutor. Sorry, let's start with the prosecutor. When and well, first of all, why and when would you want to deliver this to the prosecutor?
Before pleading guilty, before entering into the plea agreement. Because if you can get a video to that prosecutor, it softens them up.
Yeah,
Makes
but
it
people
harder
don't
for him
understand.
to want to throw the book at your client.
Yeah, I don't think people understand just how much power the prosecutor has in deciding what to charge the client with, which really does shape the ultimate sentence, especially if there's mandatory minimums. But then when it comes to deciding what kind of a plea offer to offer your client, they're the beginning, middle, and end of the decision-making process there. They have all the power. So why wouldn't you want to present them with as much mitigation as you can about not just the case? I mean, I think a lot of lawyers focus on, well, the evidence isn't that strong, and if you went to trial, you know, you might lose. And most prosecutors are going to be like, well, yeah, look at the odds are I'm not going to lose. But they don't focus on the human element of it to say, why is this person worthy of some consideration? You know, I always say people like to say, let the punishment fit the crime. I say, let the punishment fit the person. If you're not doing that work at the plea negotiation stage, you're missing a huge part of it. Why probation? What does probation have to do with it, especially in federal?
They do what's called a pre-sentence report. It goes to the judge. And to the extent that you can be proactive and instead of waiting for them to come up with what the sentencing guidelines are and objecting to them, be proactive. Tell the probation what you think they are.
Okay. And here's the other thing. I had a case where every judge, this is a know your judge thing that we talked about earlier. Every judge has a different way of engaging with the probation officer. So the probation officer works for the judge. They're an officer of the court. Their whole job is to give the judge the information they need to help decide what the sentence should be. And but it's not just a report. In federal court, the probation officer is almost always physically present at sentencing. And a lot of judges will bring that probation officer into chambers with them before the sentencing, all alone, just the judge and that, which is, talk about giving up control. It kills me because I don't know what's being said and I can't address it. But the bottom line is, if you've done the groundwork with the PO, when they go in that room, they might just say, this guy needs a break. He you know, this is a good candidate for a low sentence or probation. So you just never know.
There's very little, Doug, that a defense lawyer can do at the hearing itself, other than maybe arguing the guideline issues, legal issues of the case. But other than that, as far as mitigation, have your client do that.
Yeah. And I'll tell you another story about the PO. It was an immigration case in federal court. I'll never forget this. Because this particular judge had a habit of, the PO would be in the witness chair during sentencing the whole time. And the judge had a standing practice of kind of giving the PO the last words, you know, turn to him or her and say, well, what do you think? And this is a case where we did a video. and the video was about why the person came back to the United States after being deported, and his child had a traumatic head injury and she needed medical care, and it was a really powerful true story. And I remember the PO came in and he said he was filling in for the probation officer that actually wrote the report. And he said it before the hearing, it's guideline recommendation. I don't, there's nothing really I can say about it. And he wasn't even the PO that did it. But anyway, they played the video in court. A lot of times we play the video before, but this one was in court. And towards the end, the judge did his thing and looked at the PO and he said, after seeing that video, I understand, why he would have done that. And he said, I probably would have done the same thing if I were in his shoes. And the guy got an amazing sentence. And I was like, okay, so POs can be a big part of this process.
Oh yeah.
Anyway, so we talked about POs, we talked about prosecutors. I think I have on my list sentencing memo do's and don'ts. We talked somewhat about that, especially as it pertains to letters, but is there any other advice you can give lawyers about the sentencing memo? Yeah,
Again,
tell me.
Rather than spend 2 pages, explaining what a particular case says as precedent, take the case, highlight it, hand it up to the judge.
Yeah. So sentencing memo, I think less is more in every case. Like
Yes.
lawyers we're trained to be devastatingly thorough, but I don't necessarily think that's the way to go. How do you feel about those memos that start out explaining to the judge that the guidelines are discretionary and things like that?
That shows you nothing better to say. Judges don't like boilerplate citations to the law.
Yeah. And I see it all the time. The first couple, 3, 4, 5 pages are all boilerplate law about this guy. This is what the guidelines means, or this is what the offense was. It's all a waste of space. The judge knows exactly what the crime is, so you don't need to regurgitate it. And by the way, that's their story anyway, not ours. And pretty sure that every single judge on the federal bench by now, since it happened in 2005, understands that the guidelines are discretionary. You don't need to cite Booker anymore. You don't need to cite Fan anymore. Skip it. If there's law that matters, cite it. If not, skip it. They don't need it. Okay, so what about pictures? Can we put pictures in sentencing memos?
Sure.
Yes, we can. All the time.
Anything to make your memo different than others is important.
A picture says 1,000 words, and we got a great example of it this week. And I don't know when this podcast is going to go live, but this week was the government's filing in the Mar-a-Lago top secret documents, and they put one picture in there of these documents. And
I thought that these documents were strewn on the floor by Trump. No, the government laid that on the floor. But
yep, but I think the point was this bright orange lettering that says top secret, and the bright red that says, it's basically shouting at you that there's something really, really wrong here with the fact that anybody would have these documents. And it doesn't matter if they're on the floor of Mar-a-Lago or in his desk or in his closet. This picture is going to be the iconic picture that defines this yes. instance forever in history. And the government understands the power of one image. And I always tell my lawyers, even if you just find one image that can tell the whole story of your case, use it, because that's what people remember at the end of the day more than anything you've ever that comes out of your mouth.
Something that was stand out.
Yeah, and memorable. All right, so we have come to the point where I think, well, do you think I missed? Is there any these are long and there's a lot of stuff in there, so we can't cover everything, but is there any other great sentencing tip that you learned from these judges that you feel like we didn't cover today, or shall we move on to prison consultants?
Again, A good lawyer knows when to sit down and shut up and have your client do the talking.
Yep. That's good advice. That's good advice. Because judges know that you're there to say the things that lawyers say, and it does, and they've heard it all before from probably from your mouth too, because you've been in front of them. So yeah, clients talk. So okay, so I want to talk just so we're going to draw a line, but this is very much in line with what are we doing to present at sentencing, and there has been some publicity recently about what people are referring to as fixers, and what they are prison, well, they call themselves prison consultants, but well, for example, in the New York Times this year in June, there was something in the Sunday Times magazine that says for a price, a new breed of fixer is teaching convicts how to reduce their sentence, get placed in a better facility, and make the most of their months behind bars. And, there's a big photo there of these prison consultants sitting at a conference table in a conference room, and they're wearing suits and they look like lawyers. And I got a little worried about that because, first of all, let me say, I think that prison consultants are valuable for certain functions. But when we start talking about non-lawyers coaching our clients on how to quote unquote get a better sentence, then I start to scratch my head and say, well, I thought that was the lawyer's job. Prison consultants can tell you about where you're going to serve your sentence and how you're going to serve your sentence, which is very relevant to sentencing mitigation. They can tell you how to walk the world, how to do time, what did you expect in there. But I guess let me just put it to you. Do you use quote unquote prison consultants, and what are their qualifications, and what is their function, their main function in a case?
So the ones that we use are former high-level BOP officials, prison officials.
Okay.
They
so
know
wait a
the
minute.
inside and out of
Yeah.
the
So
system.
right there is a distinction to be made, because the prison fixers that this article is talking about were not former BOP officials. They were former BOP inmates. So that's, I think, a pretty important distinction there,
Yes.
too.
And some are con men, still con men.
Yes. And not saying these people are in this article, but in the past, other people have literally been prosecuted for fraud. They'll hold themselves out. We'll get you into the residential drug alcohol treatment program. Send us $1,000. And again, definitely not saying the people that were profiled in the Times are those people. But I do think it's important to know what's out there and what the value is of A versus B. So tell me basically, like, what kind of BOP officials would you ever need in a case, and what would they be doing for us?
Well, for example, got a case right now where the lawyer has asked me to do I have anybody who can tell the judge what this client will be facing in prison, the sex offender? And I do. I've got a former warden who can talk about that.
And we can name names because Maureen Baird I've already done a podcast with Maureen, so I'll put a link in the show notes, but she is a former warden of several BOP institutions.
And a co-author of our Federal Prison Guidebook.
Exactly. And she's affiliated with a group called Prisonology, which you just made an announcement that you've partnered with Prisonology. So why did you pick Prisonology as opposed to some other group?
Well, actually, she was working with them. She referred me to them, and they're very good.
Okay. And so Maureen is a former warden, but we have used former BOP officials like Philip Wise, who have various expertise in the medical aspects.
He's a former deputy director for health services for the entire Bureau of Prisons.
So tell me just generally, though, why would that be mitigation at sentencing?
If a client is suffering from a severe illness and the bureau of prisons says, oh, we can handle him, Phil can say, no, they can't. Explain why they can't.
Yeah. And
And
we
what-
know from our previous experience that the BOP will automatically say, we got this, it's all good. And we've had cases where we've argued that they don't, I mean, it's public record, their medical services are subpar in a lot of cases. And sometimes it goes really wrong for our clients because they have serious illness and they can't get the treatment they need.
You and I a few years ago had a client who had cancer, and we're arguing to the judge, don't send him to prison. They can't take care of him. Oh, yes, they can. And guess what? He went to prison and the malpractice on him and he died.
Yeah, he died very soon after. And there's layers and layers of this too, because another aspect is if you have a serious medical issue, you're going to go to a specific prison that is a medical an FM, what we call a federal medical
center. If it's serious enough, yeah.
Yeah. And what people don't understand is this particular person, for example, would have, if he were healthy, would have gone to a camp, most likely.
Yes.
Minimum security camp. But because he has a health issue, he's going to an FMC, which is much more restrictive. It's
it's a real prison. Yeah.
And there are people from all different classifications. So you may be a white collar offender that's in a facility with violent people that would never qualify for a camp. So it's what I call, remember back to the 3 R's, these are what we call the relativity stories, where you compare this to that. Judge, if my client were healthy, he'd be in a camp right now. But because he has cancer, he's going to go to this horrible facility that, by the way, isn't going to be able to treat him the way he needs to medically. Therefore, if this were a healthy person, he'd be doing much less, easier time in a much more comfortable facility. So he should not go to prison or get less time. So you need experts in the who know about how the BOP functions, and who are credible with the court to be able to either swear out an affidavit, a declaration, go on video, appear at sentencing to testify, right? So
credibility is so important for the lawyer. So because I asked a judge once, can you vouch for a client? Yes. And if I like the lawyer, know him, respect him, yeah, they'll count for a lot.
Mm-hmm.
It does. This is a good guy, Judge.
Yeah. Yeah.
He did what he did. Aberrant behavior. This is out of character for him, what he did. And if you have credibility with that judge, he'll listen to you.
Mm-hmm. All right. Well, I guess the last question I have is just the logistics of how do you get involved in a case? Because usually it's not the client who's coming to you when they're first charged to represent them all the way through your expertise. Yes. But usually it's going to be a local counsel that's been handling the case and they're thinking about sentencing, hopefully early. And that's when they bring you on. So I think it's important to know, just in terms of the team approach, that there's usually going to be another lawyer that's part of the team that's typically the one that's coming to you, at least for sentencing cases, right?
Yes.
So we work well with we play nice in the sandboxes, basically.
We do. We have good work habits.
And here's why I'm thinking about that, because sorry, go ahead.
It works well with others.
Yes, we work well with others. It usually is a really great working relationship. And it benefits the client to have a good team and to have leadership on the team, so everyone's rowing the boat in the same direction. What I always worry about, especially if I'm doing a sentencing video, that a client comes to me and says, I want a video. My first question is, well, what does your lawyer say? Because I don't want to be in a case where the lead lawyer, isn't on board with what I'm trying to do in a case, right? And the reason I'm thinking about that is back to this New York Times thing, at least the way the article is written, it makes it seem like these folks get involved on their own accord from the client or the client's family, and that they're not necessarily working totally in tandem with the lawyer.
Well, if they're working for the lawyer, then the attorney-client privilege extends to them. If not, then it doesn't, and they can be subpoenaed into court. What did the defendant tell you?
Yeah, that's a big deal. That's a problem. So as long as the lawyers got them under their tent and on their team, they're protected by work product or attorney-client privilege. Okay.
Yes.
All right. Well, not here to cut anybody else down. Well, a rising tide lifts all boats, and love and kumbaya and everything else. All I'm saying is, just be aware, and know what the potential pitfalls are. That's important.
For most people that are charged in federal court, the questions are, one, I want the lowest possible sentence, and with one incarceration, as it certainly is, be served in the best way possible and get home as quickly as possible. That's what we do.
And you do it well. And to circle the square on your articles about a view from the bench, you really summed it up in one passage, which was, I think, the main takeaway. And it is, quote, "We criminal defense lawyers, we are falling down on the job when it comes to sentencing." Simply stated, the judges said that they're not getting the information they need during the sentencing phase of a case. And that's what it boils down to, developing the information and presenting it in a powerful and credible way. So thank you. First of all, thank you for, it's been, I think 2014 now was the first time you found me and brought me into a case and did a sentencing video. So we're coming up on a lot of years together.
Hawaii case, we got a great result there too. In that case, the key person on the video was the expert, the therapist for the client.
Yep. And the first case was actually a New Mexico case, and this particular client said, up until the point where we did the video and the sentencing presentation, every time he was in front of this judge, he looked at him as if he were a monster. And that after the work that we did was done, the entire demeanor of the judge had shifted, and the judge actually, recognized that he had a real hard time life growing up and how that played into the offense, and wished him luck, and had just a whole softer sort of connective posture with him. So I'll never forget that. But anyway, I just want to say thank you very much for everything you do. And first of all, thank you for what you do. Second of all, thank you for, guiding me through these years and including me in the Federal Prison Guidebook. This thing is going to be, I'm going to put a link in the notes. So if anybody wants to buy this book, they can. But also just thanks for coming on the podcast. And I'm sure I'll be talking to you, later today about some case.
My pleasure.
All right. Alan Ellis, thank you so much for coming on Set for Sentencing, and we'll see you soon. That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you like the podcast, please do me a favor. Spread the word about Set for Sentencing and give us a rating and review on the iTunes podcast platform. It would really help. Last but not least, if you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.